Another thing, and I didn't know we could do this, but after last month, someone asked if we could have a live transcription as we go. And I didn't know you could do it, but you can. We've been trying it out as a firm, and I'm going to turn that on. Emma, is it visible now? Can everyone?
Yes, it is.
Okay. So yeah, this is high tech. And now, last but not least, I'm going to share my screen. There we go. All right, then Emma, you'll keep admitting folks as they join.
Yes.
Okay. This is actually one of my favorite topics. Part of the reason is years ago, when I first started practicing, I started practicing in HOA and condo law, and I got fascinated with going to meetings. I used to go to this one meeting, this annual meeting. I went with my boss at the time. It was in Central Oregon. And the first meeting I went to, there was a fist fight that broke out. And I thought, wow, this is what HOA meetings are like. And anyway, the next year, we recommended that they hire a sergeant of arms, which they did. He was an off-duty sheriff's deputy, and he just stood in the back. And I don't know what it is. Everyone behaved. I guess it's just the presence of a big law enforcement off-duty person makes people behave, but they're fascinating to me. And I also am fascinated with Robert's Rules of Order, which we'll spend probably the last third of tonight discussing. If you have questions, my preference is there's a Q&A box. There's also a chat box. Type them out in there, and then I'll try to go through them at the end. Sometimes I might not get to your questions. What we've done in the past is sent out an email to everyone with the questions and then our responses. Normally, my law partner, Bruce, is on here, and he's frequently responding to the questions as they come in. But he had, his wife bought tickets to a, I don't know, some sort of, I think, Japanese dance troupe performance in Bend this evening that he forgot about. So he's not with me tonight. So I'm flying solo. All right. Well, we'll talk about types of meetings. We'll talk about notice requirements, quorum, spend a little bit about meeting minutes. One of my favorite things to tell board members when I see board meeting minutes that are 20 pages long, and I say, there's a reason they're called minutes and not hours. They're supposed to be brief. And we'll talk about that in just a little bit. And then at the very end, we'll walk through kind of a hypothetical meeting to illustrate some of the things we're talking about tonight. Now, one thing I've started doing is giving everyone a couple of caveats before we go any further, which is a lot of the things that I say tonight. For example, I'll frequently talk about a 20% quorum is the default, because that's the default in Oregon if your governing documents don't specify a quorum. Now in Washington, things are different. And about half of you are in Washington, about half of you are in Oregon. What we were talking about tonight applies across the board. But just know that, I'm going to talk about proxies at some point tonight. It's rare, but I've seen several bylaws which completely prohibit proxies. So, and the reason I'm saying that is sometimes I'll start talking about, I'll say, suppose your quorum is 20%, and someone will inevitably raise their hand and say, well, our quorum is 10%. I know. I get that everyone's documents are going to be a little different. Just keep that in mind. Also keep in mind that some things, when it comes to notice or other meeting issues, depending on the statute and what type of community you're in and what jurisdiction you're in, sometimes the statute trumps whatever your governing documents. Other times you'll see stuff like this. Unless the bylaws specify a greater percentage, a quorum is 20%. So if your bylaws say your quorum is 10% or 5% or 75%, that's what you go with. But again, there are other statutes that say it doesn't matter what your governing documents say. For example, the open meetings requirement. if you have bylaws, and I've never seen this, but if you have bylaws that says the board can meet in secret, the law will trump that. You're subject to the open meetings requirement. Now for a hypothetical, because I want to gauge how smart all of you are, what kind of audience I'm dealing with, okay? Now, let's suppose it's a 200 lot subdivision HOA, and there's an owners meeting, and 100 of them show up. And let's just assume that quorum is achieved, and an issue is presented to the membership, whatever issue you want it to be. 97 of the folks there vote yes, 3 abstain, and there's no votes. Now, if you ever look through your bylaws, you're going to see slightly different language depending on what it is that is being voted on or what the approval threshold is. And words matter. So let's assume the bylaws say whatever it is that needs to be approved, it requires a majority of owners present in person or proxy at a meeting. How many votes do you need to approve?
101.
101. Right?
No,
No.
no. A majority of owners present.
51.
Present.
50,
Oh.
yes.
Yeah, just
And
saying.
listen, no one ever gets these right. I intentionally made these tricky, but these snippets are from actual bylaws. Okay, that's the first one. Now let's say instead of that, it says a majority of votes cast by owners present in person or proxy at a meeting. Then what do you need?
2. 97, half of 97.
Yeah. And I'm a lawyer, and that means I'm not good at math, but yeah, it's half of 97, whatever that is.
49.
49, there we go. All right, last, let's say, instead the bylaws say, in order to approve, it's a majority of all lot owners. How many votes do you need then?
101.
That's right. Who just said that? You get Colleen, you get extra
Both
credit
Colleens.
for that one. Good
I just
work.
copied the first guy.
Hey, good. So, yeah, I'm pointing this out again. Be very careful when you look at their voting threshold in your governing documents. All right, now let's talk about types of meetings. In most associations, you're going to have an annual meeting, and then you're going to have board meetings. But occasionally you'll have a special meeting of the owners. The number one reason, in my experience, that special meeting of the owners gets called is to remove a board member. And those are fun meetings, fun for me, not fun for whoever's subject to the recall. And then you have board meetings. You might also have committee meetings. Some associations specifically call out architectural committee meetings. Now, why does it matter? The notice is going to be different for each of those meetings. Whether it is open to the ownership is going to depend on the type of the meeting, the quorum requirement, who can participate and vote, all dictated by the type of meeting. So annual and special meeting, that always is going to imply meetings of the ownership. And that means that any member of the association can participate, vote, make motions. But at a board meeting, the assembly is what Robert's Rules calls it. The assembly, in that case, is just the board members. So only board members can participate, vote, make motions. But because almost all of you are going to be subject to open meetings requirements, those board meetings, you must give notice to the owners, and the owners are entitled to sit there and listen to your deliberations and your discussions. And most associations have open forums, but in terms of conducting business, only the assembly. And in a board meeting, that's the board. Now, committee meetings, generally speaking, aren't going to be subject to open meetings requirements unless a quorum of the board happens to also be on the committee. Usually ARC or architectural committees aren't subject to open meetings, but I've seen bylaws that do mandate ARC meetings even be open to the owners. Notice requirements are different for annual meetings. Generally, it's notice no less than 50 days or no more than 50 days, no less than 10 days. Board meetings, depending on which jurisdiction you're in, usually a 3-day notice requirement in a conspicuous place or electronically. And so again, the type of meeting matters. My next trivia question. In a homeowner or a condo association, can the chairperson of the board vote?
Yes.
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 Or can they only vote to break a tie?
Yes.
I don't.
Some
Depends
say
on
yes.
the Rules. Vote.
Most folks say chair can only vote to break a tie. And that's kind of correct. By the way, I'm just noticing there's some chat. Okay. I'll get to those. And that is what Robert's rule says. But keep in mind, in most associations, the board members and the officers are the same individuals. But let's say in a corporation like IBM might have 13 directors and 10 officers, all different people. So a chairperson is an officer. Okay. Now, generally, the chairperson is also a director, and they're wearing 2 hats. And so when it comes time to vote at a board meeting, you're always voting in your capacity as a director, not in your capacity as chairperson or secretary or treasurer. Those are officer positions. Board members vote at board meetings. So the answer to this question is absolutely. The board chairperson absolutely should vote. They're supposed to vote. They have a duty to vote. They're a board member in addition to the chairperson. Does that make sense?
Yes.
Yes.
Okay, good. Now let's talk about everyone's least favorite subject. The open meetings requirement. And I say least favorite because here's what I often get in response when I talk about the open meetings requirement. Board members will say, well, it's impossible to conduct business or get things done if we can't email each other all the time or have Zoom meetings in between board meetings. And I say, well, I don't know, maybe that's true, but it doesn't matter because here are the requirements. The open meetings requirement is triggered anytime a quorum of the board convenes in person or electronically and discusses association business. So that means if there's a 5-person board and the quorum requirement is 3, and 3 of the directors run into each other at the grocery store and start talking about the collection of delinquent assessments, that is in violation of the open meetings requirement. And discussion of association business is not only in person, but electronically. So if you're making decisions and having discussion and deliberation that is appropriate for an open meetings, you're most likely in violation of the open meetings law. Now, I hope all of you in your minds are thinking, of course I know this, we've never violated the open meetings requirement. Now, years ago, there was a board that I represented. They represented for quite a while, and they had monthly board meetings, but an hour before the board meeting, they convened at a bar across the street and all agreed how they were going to vote at the meeting in 30 minutes. You can't do that. I hope that's obvious, but you can't do that. Now, I remind board members of the policy behind open meetings. So the policy is that members of the association have a right to listen and observe your deliberations, the questions you ask, and how you came to vote yes or no on whatever the issue is. With that in mind, I get the question sometimes, well, if I email the board to confirm that the meeting is still on at 7 o'clock at the public library, is that a violation? No, that's not a violation. That's not substantive business. I don't think that's an issue. And then the question is, well, how do I know if it's association business or not? And my response usually is based on this famous Supreme Court case. I don't remember who the justice was, but it was one of the first cases involving free speech and pornography. And you probably all heard this before, is you know it when you see it. And most of you here are smart enough to know it when you see it. You know when substantive business is being discussed versus procedural things, and therefore subject to open meetings requirements.
No.
Now, there's an exception to open meetings, which is called executive session. And there's only 4 topics that are appropriate to discuss in executive session. And keep in mind, there should be no voting or decision-making ever in executive session. It is only for discussion. And it's for discussion of what the law would consider sensitive topics. So consultation with your lawyer, discussion of personnel issues if you have on-site employees, negotiation of third-party contracts, and collection of delinquent assessments. So it has to be one of those 4 topics in order to be in executive session. And again, it's only for discussion, no voting. And so the mechanics of it would be, you'd be in an open meeting, properly noticed. A board member would make a motion to adjourn to executive session to discuss whatever topic. You would either ask the members to excuse themselves, or sometimes the board goes to a different room. You have your discussion. And then if a decision needs to be made, the decision needs to be made in the open meeting and reflected in the meeting minutes. That's how it works. Questions about open meetings?
Yeah, Kevin, what are the ramifications or the penalties for violations of the open meeting law?
Yeah, now, I was about to say not much, but I don't want to say that. Here's where it could come back and bite you. Let's suppose a decision inappropriately was made and there was some financial harm. Let's say you didn't follow appropriate procedures. You hired a landscaper did something wrong, you still paid. There could be a potential for damages for that owner's share of the common expense. So it'd be minimal in most cases. Where it usually comes up is when there's a bigger issue and the association gets sued. They usually throw in lots of stuff about violations of procedural things. So in terms of consequences, there could be serious consequences, most likely, though. No, I'm not going to say that. No, just yes, there are consequences, Dennis.
Kevin?
Yes,
I have a question.
sure.
If I know if we're consulting with an attorney, our attorney, that we wouldn't need, to follow that rule. But what if the board is discussing the issues that are
Subject to legal.
Yeah.
Yeah. The statute, Colleen, you're in Oregon. The statute says consultation with legal counsel. I read
Right.
that to mean they need to be part of the conversation in order for that privilege to apply.
Okay, so we shouldn't discuss anything amongst ourselves
I
unless
wouldn't.
about a particular situation.
Yeah.
Okay, got it.
Yeah. Now here's another question I get. It's this: what if I email one director and then that director emails another one, and then they just keep forwarding so that a quorum is never on the same email chain? And my response to that is, if it's obvious you're trying to circumvent the open meetings requirement, you're going to get in trouble. So even if you're technically not, you're certainly violating the spirit. And courts treat this open, just like school boards and municipalities. That open meetings requirement is considered sacred. And again, remember the purpose. Owners are entitled to witness and observe your deliberations, your discussion, and why you voted the way you voted. Okay.
Kevin, there's a couple of questions about open meetings in the Q&A.
Oh, okay. Does the president have the right to ask a person in the audience to? Yes. So particularly in a board meeting, again, only the board is entitled to participate and vote. Now, if during an open forum where owners, have the right to say what they want to say, They do have that right, but not if they're being uncivil or disruptive. You have every right to ask anyone disrupting a meeting to leave. When I've been at meetings where I've threatened to call sheriff or whoever, and that usually is enough to get people to behave. But yes, you can ask anyone that's disrupting a meeting to leave. Does the board have the right to do business and then ask for public input? Absolutely. The board has the right to ask for input from anybody, paid experts, owners who might have a particular expertise. Yes, you're entitled to ask for input from anyone.
I think specifically that question was asking, can you do business and wait for questions until after?
Oh, yes. Yeah,
Yeah,
absolutely.
that was my question. That was my, I was curious. The board has the right to hold their meeting, do their business, and then at the end, they can answer any public input as opposed to answer it through the, during the meeting, right?
That's correct. And in my experience, boards that allow owners to interject the meetings that should be 30 minutes end up being 3 hours. But again, I think there is value in owner input, but it needs, I would say have it either, usually customarily it's at the end of a meeting, but there's nothing wrong with having it at the beginning of the meeting, end of the meeting is customary.
Thanks.
You betcha. Now let's talk about quorum. And I guess my first question is, what is quorum? Usually when I ask that, people give me a number or a percentage. And I say, well, that's your quorum, but what does quorum mean? And quorum means the number of individuals in person or by proxy necessary in order to conduct business. And again, it depends on the assembly. You're going to have a different quorum requirement for board meetings than you do for owner meetings. I'll give you an example. This is the quorum requirement for any owner's meeting, and it's 10%. Same set of bylaws, though, if you go down to directors, different article, quorum is a majority. So if it's a 5-person board, a majority, it would be 3 individuals would constitute the quorum for a board. Make sense?
Mhm.
Now, let's say it's your annual meeting and your quorum requirement is 10%. And it's supposed to start at 10 a.m. and at 9:59, you realize you're at 18%. And then the time comes for the meeting to call to order and you're still at 18%. Can you continue with the meeting? You cannot. You cannot conduct business unless quorum has been achieved. Now, you could certainly sit around and chit chat and have a town hall meeting, but in terms of decision making, you can't, not unless quorum has been achieved. All right, let's talk about proxies.
I have a couple questions first that just came to me.
Okay.
Back to open meetings. Can you approve meeting minutes and agendas via email without violating the Open Meeting Act?
No, those are all business of the board. Approval of meeting minutes, all should be done in an open meeting.
Okay, you mentioned personnel. Can that include one of the members if there are no personnel? Also, you mentioned administration. Would preparation of documents be considered administrative and therefore not substantive?
Preparation of document, it depends on what it is. I guess if it's to check on the status, I don't see a problem with that. But if it's, should we put this language in section whatever of this new amendment to the bylaws, I'd say that needs to be done in an open meeting. Was there one more piece to that, Emma?
Not on that one, but there was, if someone submits information that is anonymous, can the board ask to know who that is?
Yes, they don't have to, but you're entitled to ask who the author is. And if no one comes forward, you have no obligation to consider it.
Okay.
Someone asked how the number of directors is determined. Always determined by your bylaws. Usually your articles of incorporation will also say it. There is no formula, though. There are large associations with 5-person boards. I've seen small associations with 9-person boards. My preference is always to have it an odd number, but it's always going to be dictated by your bylaws and usually a lawyer, whoever wrote them. Someone asked about, folks, I'm going to ask you for 60. I feel like I'm losing my voice. I'm just going to get some water. Give me 60 seconds and I'll be right back.
I have a question. Do minutes have to be read at the meeting before they're approved? Or can the reading of the minutes be waived?
I will
Anybody know?
make sure Kevin gets that when he comes back.
Okay, I thought maybe some of you others would know.
I think the answer is no. I sure hope it's no.
You mean
Otherwise,
reading,
it's
you
gonna make-
mean reading the minutes aloud during the meeting?
Do they, can a board accept the minutes by making a motion to, they maintain they have a copy, and I make a motion to suspend with the reading of the minutes?
Yeah, I don't think that they have to be read in the meeting. I think you read them prior to and then vote to approve them or disapprove them with changes or whatever, or approve with changes.
Okay,
I think that may depend on whether or not they were available for the owners to look at prior to the meeting.
they were not.
Oh, that's different.
Oh, wait a
So then
minute,
that's different.
they
Yeah.
would be on the website,
But the owner doesn't approve them, the board approves them, correct?
correct?
Yeah.
Kevin, are you back?
He went next door for a beer.
Kevin,
He's back, but he's muted, I think, or something.
he doesn't look like he's muted. What's going on?
We're gonna lose our quorum if he doesn't get back soon.
Oh, no.
He got that drink of water, now he has to go to the bathroom.
This is weird.
He's muted.
This is really weird. Does he not realize that nobody can hear?
Can you hear me?
I can.
Okay, good. I'm the one who raised the question about basically the definition of personnel as one of the 4 exceptions for being able to meet in executive session. And the question is, does the personnel have to be one of the personnel members of the board, or can you define personnel as one of the members of the association? So basically, if you're talking about someone who's doing something illegal, is it, does one have is that one of the 4 exceptions that you do not have to disclose, that you can discuss in executive session?
Gotcha.
And
Okay.
I'm not sure I heard, I didn't, I perhaps didn't pose the question properly, so I'm not sure I heard an answer to that question.
Got it. I don't think we've got one. No one can hear Kevin, right?
No.
Okay, good. I'm not crazy. I'm gonna call and see what's.
I think if I'm throwing my 2 cents in, generally when they say personnel, they mean employees of the association.
Okay,
If the issue is one of the board members doing fraudulent activities, that would fall under legal. And yes, you can move into executive session to talk about that matter.
mhm.
Doesn't it also apply to owners that you need to discuss that you would not talk about in an open session?
Right,
Right, so they would
Sure.
be discussed in executive session.
right.
Okay,
But no decision, I mean, decisions.
But no
yes, you
decision,
can't
no,
vote.
no, just
Can't vote on
discussed.
that.
Yeah.
Yeah.
And I have a question about the minutes. So normally we distribute the minutes after the meeting. The other board members have had a chance to look at it, to the owners, to all the owners of the association, because it'll be another month before the board can approve them in a board meeting.
How about now?
Is that okay?
Yes.
There we
Yes,
go.
that is how it's done.
How long have you not been able to hear me?
Long time.
Since you went,
Since you came back.
So my slides are on one monitor and I don't, Emma just called my office phone. I'm very sorry. So did you hear about any of the bit about proxies?
No,
No.
Son of a gun.
Last
All
we
right.
heard was when you were going to go get some water.
Oh, so you didn't hear
Okay,
me
but-
thank you. You didn't hear me thank you for your patience.
no, we thought you
Okay.
went across the street.
We do have one question if we can before
Yes, go ahead.
we start, which is about the difference. I'm going to go back to it here. Oh, the difference between personnel, can that include one of the members if there are no personnel?
No, personnel means on-site employees or managers who get paid and are not members. Actually, you could be a member and also personnel, but personnel implies some form of employment relationship.
So that means the board is required to conduct conversations about the illegal activities of a member in an open session?
Tenderly.
No, now, if it's going to be something with potential litigation and
Mhm.
you're gonna discuss it with your lawyer, that would be appropriate.
Okay, so,
Yeah. Yeah.
all right.
I'm gonna skip most of proxies. I'm gonna send out an email with an article that I wrote a while back that summarizes that, just because I want to move through. Now, here's a question for you. Can a board member who can't make it to a board meeting give a proxy to another board member?
No.
Oh,
Good. Oh, I'm so
No.
happy to hear that. You are correct. Yes, you cannot. Now, keep in mind, owners elected you because they trust your judgment. They want you to act in their interest. And so granting a proxy is a breach of that duty. So yeah, if you can't make it to a meeting, you can't make it. You can't give a proxy to anyone for the purposes of a board meeting. Now, for an owner's meeting, sure, if you can't make it, even though you're a board member, you're also an owner, but you'd be given a proxy in your capacity as an owner if you couldn't make it to an annual owners meeting.
I think it's also important to cite that in the statutes, it says that a board member cannot abstain unless there's a conflict of interest. Their vote will be assumed to be affirmative.
That's right. Ladies and gentlemen, let me introduce you to my dear friend, Catherine Gorell,
Oh,
Mhm.
who I met shortly after I left my old, when was that? Probably 8 years ago.
a bit of time, yes.
And Catherine and I spent, I don't know how long, rewriting all of their governing documents, having town hall meetings, and we've been pals ever since. So good, yes, good point, Catherine. I'm going to talk about meeting minutes for a moment. And again, I said earlier, I call them meeting minutes, not hours. Robert's rules says, here's what should be in your meetings. Location, who's present, time, but then other than that stuff, the motions, and did it pass? Really, that's what Robert's rules should be in your meeting minutes. Now in Oregon, there's an additional requirement to your meeting minutes, and that is the meeting minutes must reflect which way each director voted. So if 3 directors voted yes, you record director X, Jane, John, Jill, whatever voted yes, and the other 2 voted no. If it's unanimous, you can just put unanimous because all the directors will be listed at the top. So really, I mean, this motion, did it pass? And then the time of adjournment. Now,
What about Washington?
Washington, you don't have to record that. I think it's a good idea, mainly so that if there's an issue in the future about whether it was approved, it's easier to identify. Is that you, Joel Gilpin?
Yeah, I was just wondering if you have to say Bob, Jim, and Pete voted yay, or
Yeah.
just say 3 board members voted yay
Yeah, no, it needs to name them individually.
in Washington.
Yep. No, not in Washington. No, not in
Wash-
Washington, but best practice to do that.
Okay,
And Joel, you are on my call list because you emailed me a couple of days, and I've got a couple of recommendations for you. So I will
Great.
be getting a hold of you tomorrow.
great, thanks.
All right, now now I don't want to say this is a hard and fast rule, okay? And here's why. I frequently get the response of, well, a lot of our owners can't attend meetings or they live off site, and the only way that they can keep up on what's going on here is through the meeting minutes. And if that's the case, I say, fine, be a little more thorough. But part of the reason Robert's rules discourages having a narrative of the discussion and deliberation, there's 2 reasons. One, often directors are less willing or interested in speaking freely if they know every word is being dictated, whether it's on a tape recorder or a transcription. 2, there's often disputes later on when it comes time to approve the meeting minutes where one director says, that's not what I said. So there is no requirement to have any of the narrative or summary of the discussion. Use your discretion when it comes to that. One thing I will tell you, if you do meet an executive session with your lawyer, don't put in the meeting minutes all of the advice that your lawyer gave you, because that has the potential of waiving attorney-client privilege. Also on our website, we have just a sample set of meeting minutes. I'm not saying that this is the format you should use. It's just guidelines. It's got motions, who seconded it. There's a point of order, you put in that in there. But in general, it is motion and who voted which way. All right, ladies and gentlemen, buckle up. This is my favorite thing to talk about. One of my favorite things to talk about. Parliamentary procedure. Now, in Oregon, the statute says HOAs and condos must use Robert's Rules of Order unless the bylaws say otherwise. Washington doesn't have that statutory requirement. Most bylaws say Robert's Rules. Sometimes they don't, and the default is Robert's Rules. And in the United States, most organizations use Robert's Rules of Order. In Canada, most organizations use a much easier form of parliamentary procedure called Sturgis. It's actually way easier. But in the United States, we love our Robert's Rules. Now, fun fact, Colonel Robert, he was from England, served in the Civil War, and you know where he retired to? Right here in Portland, Oregon. And he was a member of a church in downtown Portland. And he used to hang out after church and sit around at these committee meetings of other parishioners, social committees, all this stuff. And he started to get frustrated because nothing ever got done. There was a lot of chit chat, a lot of debate, but no action ever taken. So he thought to himself, well, you know what? I'm going to start to write down everything I remember of parliamentary procedure from my time in England. And that is the origin of Robert's Rules. This is the 11th edition, which was the current edition until just a few months ago. The 12th edition is out now. But I suggest, I have a copy at my office, I have a copy in my car, and I have a copy at home. If I'm ever bored, I love this stuff. This is I call it my meeting Bible. Now, you're not going to believe me, but at the end you will. This is a thick book, 1.5 inches or so. And when I tell people what I'm about to say, they don't believe me, but believe me, you can boil this entire book down to the following 4 concepts: motion, second, debate, vote. That's how everything should happen. Everything: motion, second, debate, vote. Now, keep in mind, Robert's Rules is a mechanism to keep control of large groups. So, you know, I've been to a lot of board meetings in someone's living room, and it's, 3 board members and 2 owners. Do you need to be strict about Robert's Rules? Probably not as strict. But again, Robert's Rules, it's a wonderful tool to control large groups, especially groups that have differing viewpoints. Now, the question you might have then, why is this such a large book if that's all it really is? Well, there's a ton of nuances, right? Like when it comes to debate, Robert's Rules said you should alternate between folks that are for the motion and those against the motion. Folks that haven't spoke first have priority over those that have spoken. There's different forms. There's, primary motions, secondary motions. There's a whole chapter on methods of voting. Voice vote, all in favor say aye, all opposed say nay. Written ballots, paper ballots. The newest edition addresses electronic voting. So yes, there's a lot of information in there, but really it boils down to motion, second, debate, vote. And if you memorize this, you can control the meeting. Now, I chair a lot of annual meetings, often for large associations. And so far, they haven't got too out of hand. The first thing I do is I say, hey, everybody, we're going to follow Robert's Rules of Order. I promise every one of you that if you want to speak, you will be entitled to speak. And I just go through a list of rules, and then I say, does anyone object? Now is your time. And no one has ever objected. And I think that sort of silent recognition of the rules has an effect on folks and their behavior. And so that's what I recommend starting. Lay out the ground rules. If anyone wants to discuss it or change it, you can talk about it, but set out the rules and clarify that you're going to be using Robert's Rules of Order. Now, I have a cheat sheet. I'm not going to show it to you for too long because I'm going to ask you some fun trivia questions. It's also on our website. I usually have this with me at all meetings too. Okay, now we're going to get to the fun stuff here. This is a pretend meeting, okay? And we're going to walk through the process. Now, let's say quorum has been established, meeting's been called to order. We have achieved quorum. And Ken raises his hand. I'm the chair, of course, and I say, I said, the chair recognizes Ken Miller, and Ken stands up. He says, I make a motion to spend $100 to renovate the clubhouse. Now that's a proper motion because there's no other pending motion out there. So I say, great. Now again, motion, second, debate, vote. The motion doesn't go any further unless there's a second. And the reason Robert's Rules requires a second is because Robert's Rule says at least one other person of the assembly must want to talk about it. And if not, you don't talk about it and the motion dies. So a second is important. Now, I don't want to confuse everybody, okay? But Robert's Rules also has a section for small boards, which is 13 or less. And it says, for small boards, you don't actually need to have a second. In fact, you can actually have debate anytime you want, but I don't want to get into those weeds. This is more for annual owner meetings or a special owner meeting. Okay, so now we have our second. Then we move into debate. So we're talking now. Maybe we don't need to spend the money right now. And some folks are saying, yes, let's do it. And then all of a sudden, I don't know, let's say Dennis raises his hand and says, and I say the chair recognizes Dennis. And Dennis says, I'd like to amend Ken's motion. And instead of the motion being $100 to renovate it, I want to spend $2,000 on it. It's the same thing. Motion, second, debate, vote. So Dennis's motion needs a second, and assuming it's second, and then we debate. Now, keep in mind, we're only debating whether to amend the motion to make it $2,000. We're not deciding whether or not we're even going to renovate the clubhouse. All we're doing is deciding, are we amending the motion? And let's say it's approved. Then we go back to debate. Now we are debating the amended motion, which is to spend $2,000 to renovate the clubhouse. So the debate continues, and Emma raises her hand, and I say, the chair recognizes Emma, and Emma says, we should table this motion. Now keep in mind, a motion to table is often appropriate, but then Emma follows it up with, because I'm hungry. As the chair, I would say, Emma, that is out of order because Robert's Rule says you should not make a motion to table strictly for the purpose of avoiding discussion. Looks like my main camera just froze. Let me get back. So I'd say, Emma, you're out of order. And then we would resume. Now, if Emma's motion was, I make a motion to table because we should create a committee to do some research to figure out actually how much it's going to cost. Or maybe we should talk to some contractors. Now that's an appropriate reason to table. And that would be okay. But otherwise, the motion to table because Emma's hungry, that's out of order. So now we're back to the debate. Now, a point of order always stops the meeting. It's an immediate halt to it doesn't matter where you're at in the process. If someone makes a point of order, the meeting stops until that's addressed. So now, depending on what the point of order is, sometimes it can be complicated, and it's perfectly fine for the chairperson to say, we're going to take a 5-minute recess. I'm going to consult Robert's Rules, or I'm going to call my lawyer, or I'm going to call a parliamentarian. That's perfectly fine. But the meeting cannot continue until a point of order has been dealt with. So if the point of order had no validity, I'd say, no, point of order is out of order, bye. But if it did have any validity, we'd have to address that and fix any procedural issues we might have. So keep that in mind. Now, so we're still on the discussion of whether or not we should spend $2,000 to renovate the clubhouse. And Catherine raises her hand and I say, chair recognizes Catherine. Catherine, out of left field, nothing to do with the clubhouse or renovation. Catherine makes a motion to increase our reserves. That's out of order. Because you can never have a main motion while another main motion is pending. Now, let me go back to this chart. This isn't a hierarchy. So main motion is at the bottom. So anytime a main motion is in play, if someone makes a motion higher than that, that's appropriate. But let's say we're on the motion to amend. You can't make anything lower, like a main motion, until the motion to amend has been addressed, okay? And I'll come back to that in a second. So I would say, Catherine, you're out of order. Now we're back to the debate. Now, have you ever been in a meeting and someone yells out, I call the question? You ever heard that?
No.
No.
Yeah.
I've heard it a lot. I don't know where it comes from. There's nothing in Robert's rules that says call the question. I think I kind of know the origin, but the appropriate motion would be a motion to end the debate. And again, motion, second, debate, vote. Again, almost everything requires a second. Now, some things are not debatable. Some things you don't have a debate, you have the second, you immediately go into vote. It will also tell you if whether or not it's amendable, and then it also has the voting threshold. So let me go back to this. So let's say we have a motion to end debate, it's a second, and then I'd say, okay, all in favor of ending debate, say aye, say yay, and let's say the yays carry, the debate is ended. Now, a good chairperson will always restate the motion before the vote occurs. So I would clarify and make sure everyone's on the same page. I'd say, okay, folks, the vote is now whether or not we should spend $2,000 to renovate the clubhouse. We have the vote. I announce the vote. Now, keep in mind, if it's something important, I wouldn't do a voice vote. I would do a ballot vote so that there's paper records of that. And most of the time in your meetings, owner meetings, I would do paper votes so that there is a written record. And those votes you should keep as association records. So I announce the vote. Now, there's nothing right now. Now, let's say Catherine raises her hand. I say chair recognizes Catherine. And then Catherine says, I make a motion to increase reserves. That's okay, because there's no other main motion pending. Now, let's suppose before we can even get a second on Catherine's motion to increase reserves, Emma raises her hand and says, I make a motion to adjourn. Can Emma do that? Absolutely.
think so.
In fact, Emma could have done it right at the beginning of the meeting. Let me go back to this chart. You see the motion to adjourn? That's the highest motion you can make. Do you know why? Robert's rule says if a majority of folks don't want to be at a meeting, they shouldn't have to. And I very rarely, a couple of times, I have represented owners in disputes against the HOA. Very rarely. And I have done things like this, engineered things like this, where the meeting gets ended immediately in accordance with Robert's rules. So don't, this little chart is our little secret. We don't tell anyone about it, but do remember it. Anytime if someone makes a motion to adjourn, you deal with that motion, and if it carries, the meeting is over. Was that fun? I love it. I think this is fascinating stuff. Okay, we've got 10 minutes or so for Q&A. I'm going to start with the Q. Okay, I think I covered that. Okay, if for an annual meeting a proxy is submitted, but no one is named to vote on their behalf, is it valid? It depends. If the proxy says something like, if no name is put in here, then to the board chairperson, that's fine. Even if there's no name, then the default would go to the board chair. But if it doesn't have that language, the proxies of no use because there is no proxy holder named. Here's a question. Let's say I can't make it to my annual owners meeting. Can I give a proxy to my mom who's not an owner there, doesn't even live there, lives in a different state?
No.
Who said, why? Who said, why?
Well, the person isn't a legitimate, doesn't have a legitimate right.
That's my mom. That's my mom. No, I'm just kidding. No, the short answer is, and I haven't seen it very often. Some bylaws say the proxy holder must also be a member. That's not common though. And so, yeah, they don't, I can give a proxy to anyone I want. My mom, my lawyer, even if they're not owners. Now, again, your bylaws might have a restriction on that, but if they don't, there's no requirement that in an owners meeting, the proxy holder be an owner. They usually are, but there's no requirement that they are. Taping meetings. Whew. I highly recommend against it. And some of you are going to say, that's crazy. We do it as a practice. That's the way we do our minutes. My response is keep doing it. If that works for you, do it. But again, the reason I don't like it, board members, even folks in the audience, even as a lawyer, if I'm in a meeting, I am less reluctant, I'm reluctant to speak freely if I know I'm being tape recorded, even though I'm not saying anything crazy. Most folks, though, they are more reluctant to speak freely if they know they're being recorded. That's one. Two, meeting minutes should be brief. And if the purpose of taping is to recreate your meeting minutes, you don't need to do that. Just take handwritten notes. That's all you need. Now, some of you might say, well, we tape it and then let owners listen to it because that's only, again, it might make sense for your community. My preference is no. There's also issues of, do you need everyone's consent to do that? And those laws are complicated. They're also different between Oregon and Washington. But generally, if you tell everyone you're recording and they stay there at a board meeting, that's fine. My preference is no, but I also recognize that it makes sense in some circumstances. And then follow up, is it better not? Yeah, similar question. Now the chat, let's see. A bunch of you told me that you couldn't hear me. Sorry, go ahead.
I have one that just came to me, which is, are there any records that must be maintained in paper versus electronically?
No, there's not. So proxies you have to keep for a year after the meeting. But if you scan those into a digital format, that's perfectly acceptable. Other association records, some you have to keep permanently, governing documents, meeting minutes, but a scanned digital version, perfectly fine. That said, there are some older documents that talk about, that the board shall maintain physical copies of certain things. If you do have some language like that, follow that. But in general, electronic records, perfectly acceptable form of storing association records. Someone asked, can a board member bring a lawsuit against the board or a formal complaint against the board, thus utilizing the HOA's money? Generally, no. A decision to litigate, it takes a majority of the board. So a lone board member wouldn't have the authority to spend association funds for a lawsuit against the board. Unless a majority of the board said the board member could, but I don't see that happening. Must board meeting minutes be distributed? I say no, but available on request. And Roberta, yeah, you're in Washington. They are an association record, and so you're right. Generally, yes, they have to be made available on request. I was trying to think if I've ever seen language that mandates the distribution of board meeting minutes to owners, and I don't think I have. So no requirement, but if requested, must provide. And I think as a best practice, make them available on your website, email them, but make them freely available as a best practice. Someone asked, does it have to happen in the order of motion, second, debate, vote? Generally, yes, that is the order. The exception, and I do have a small slide on Robert's rules for small boards. So in your board meetings, motions don't need to be seconded. Informal discussion is permitted while a motion is pending. Chairperson doesn't have to stand. Did you know that? At your owner's meeting, if you're the chairperson, you're supposed to stand when you put the question to a vote. So there, it's less formal for small board meetings. And so this meeting we walked through, that's an owner's meeting. So if it's a board meeting, no, you don't need to follow them that to a T. But I'd say get in the practice of it. It makes your meetings go smoother. The other thing it does is it focuses people. A lot of the board meetings I've been to that have taken 3 hours, which I don't mind, I get paid by the hour. It's usually a lot of discussion and no one is sure what the motion is. And so the discussion is not productive. But when you have a motion that everyone is focused on, and then you lead to the discussion, it's a much more productive discussion in my experience. All right, next, how do you feel about sending approved minutes to all owners 1 week after? I feel very good about that. I think that's a proactive approach. It's a good way to be transparent and get information out to the owners. Great question, Karen.
What minutes? Owner annual meeting minutes, or are you saying board minutes?
Karen, I think was say, I'm not sure, Karen. I would say, I'm guessing board meeting, it's got to be board, because your annual meeting minutes wouldn't be approved until the next year.
This would be on our quarterly meetings, not
Board-
necessarily board meetings.
Oh, okay, okay, gotcha. Yeah, I would say it's best practice to distribute any meeting minutes to owners in an easy fashion. Someone asked, how long do you have to keep ballot votes? In Oregon, the statute says at least a year, but my advice is a little different, which is much longer. Because the statute of limitations, if you get sued over whether or not the vote was appropriate, is longer than a year. If you don't have space for the paper ballots, scan them. But I'd say keep those ballots a minimum of 10 years. My preference is just keep them forever, just scan them.
Kevin, what's this? I'm sorry, what's the statute of limitations on what you just said?
On
that
you getting sued?
Yeah.
It depends. If the claim is for breach of fiduciary duty, that's 2 years in most, in both. But if it's for breach of covenant, that's 6 years.
Okay.
So it kind of depends. So that's what 10 covers you there. Someone asked, if someone submits an article to your HOA newsletter and want to be anonymous, can you deny it? Sure, you can. Now, if it's a really good article with helpful information, I'd say use your discretion and publish it. But if it's something that doesn't have anything of value and someone wants it posted anonymously, you have every right to deny that if it's the association's newsletter. Someone asked, how do we get minutes and agendas approved to send out if we can only approve them at the open meeting? Yeah, I mean, if you only meet quarterly, owners are only going to get it after the next quarter's meeting and the previous minutes were approved. So there's going to be a delay for sure. Annual meeting occurs and the secretary resigns a week later. Who's responsible for those meeting minutes? Ooh. So the chairperson can appoint anyone to take meeting minutes. So if there's a willing volunteer that is good at it, the chairperson has every right to appoint anyone they want to take meeting minutes. Now, generally that falls under the secretary, but if they've resigned and there's no one to fill that gap, chairperson can have someone fill it. Wow, I think, Emma, did I cover? And look at that, I'm only 1 minute over time. So thank you, Emma, do you know what next month's topic is?
Oh, I can know in 2.
As soon as you pull it up. Well, thank you, everybody. Give us, I don't know how bad the snow is and if folks are going to be coming into work tomorrow. So give us till Monday to post this to the our YouTube channel. We'll send out an email with a link. The sample minutes, the Roberts Rules cheat sheet, and sample proxies are on our website at Harker Lepore. Okay, what's next month's topic, Emma?
It's understanding and amending governing documents.
Oh, that's another good one. Well, thank you, everybody. Hopefully you learned a little something. hopefully you don't have to drive anywhere and you're nice and warm. I'm about to see if I'm gonna be able to leave the office and go home. If not, might be sleeping here. We'll see.
Good luck to you.
Thank you.
Take care, everybody.
Yeah,
Good night.
thank you.
Bye.
Thank you.